Lamb, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program with the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 27 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one advising services are available at no charge. Today's webinar, Trademark Basics, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. We are recording today's presentation, and it will be posted on our website, virginiasbdc.org. Due to the large number of participants, everyone's microphone is muted, but if you have questions during the presentation, you can type those into the Q&A box. We have also enabled the live transcript function, which you can show or hide via your own meeting controls. And now it is my pleasure to introduce our presenter for today's session, trademark examining attorney, Marissa Terrell. And Marissa, I'm going to say right now, I forgot to ask for sure, is it Marissa or Marissa?
It's actually Marissa.
Marissa, I'm sorry I didn't ask that before. All right, so Marissa, that's beautiful. Marissa began her trademark law career at the USPTO in 2000. After her departure from the USPTO, she worked as a solo trademark practitioner, in-house trademark attorney consultant for Lockheed Martin and Leidos corporations, and trademark and fashion law professor at her alma mater, Howard University's School of Law, HUSL. In 2015, Marissa was recruited to manage the USPTO Trademark Law Clinic at HUSL and was instrumental in helping to develop a patent clinic at HUSL in 2019. Marissa returned to the USPTO in 2020 and currently works as a trademark attorney advisor in the Office of Trademarks Customer Outreach, where she delivers educational content on advanced trademark topics to experienced practitioners. She earned her JD from Howard University School of Law, her BA magna cum laude from Pace University in New York City, and is admitted to the Maryland and District of Columbia Bar Associations. In her spare time, Marissa volunteers with High Tea Society, a life skills program for DC girls. Please join me in welcoming Marissa Terrell.
Thank you so much, Sheila. I really am happy to be here, and I want to jump right in because we have so much great information to share. So welcome to Trademark Basics. Again, my name is Marissa, and I am an attorney advisor for Trademarks Customer Outreach at the U.S. Patent and Trademark Office. I'm here to talk to you about my favorite topic, which is trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. And guess what? We're going to talk about where you can go for some free help. We're going to cover a lot of material, but don't worry. I understand that the Virginia SBDC will share the slides with you in a few days. So before we get started with the presentation, let me share some ground rules with you. Unfortunately, I cannot give legal advice. This means that I cannot answer specific questions on whether a particular mark is eligible for registration, and I cannot offer opinions about common law trademark rights, state registrations, or trademark infringement claims. But there's so much more that I can talk about. Let's talk about the nuts and bolts of trademarks. So trademarks are a type of intellectual property. The property itself is intangible, but still can be bought, sold, inherited, traded, and protected. Trademarks provide legal protection for a brand. Look at all of these great marks here. Some of these are like truly some of my favorite brands that I grew up with. You'll notice that all of them are in black and white. Why are they not in color? Well, we'll talk about that in a minute. But when you see these marks, you should immediately think of a specific good or service. You see this giant M, you think of perhaps hamburgers, Big Mac. When you see the Coca-Cola scripted wording, you might think of soft drinks. Or this half-bitten apple here, you might think of computer goods, computer devices, mobile devices, earbuds. Trademarks indicate source. In other words, trademarks are how customers recognize your goods or services in the marketplace. They provide a legal protection for a brand. And just a note, we're defining brand as a marketing concept tied to how people feel about a product or service. A trademark is very different from a patented invention or a copyrighted creative work. Bear in mind that just because you own a trademark does not mean you legally own a particular word or phrase. Trademarks only give you exclusive rights to the word or phrase when you're using it as a brand for your goods and services. That means you can't stop other people from using your word and phrase in the English language, and people don't owe you money just because they use your word or phrase. Let me give you an example. Apple. Apple Inc. has the exclusive right to use the word Apple as a brand name to identify a number of computer goods. But Apple Inc. does not own the word Apple, and they certainly don't own the word Apple to identify fruit. A trademark registration means that you have the right to use a specific word or a specific design in connection with specific goods and services. Let's look at these traditional marks. Traditional marks include brand names, slogans, and logos. Here are 4 different marks owned by Coca-Cola Incorporated. Coca-Cola, the word mark. The slogan, it's the real thing. A composite mark with the design of a Coca-Cola bottle with scripted wording in the middle of a circle with a banner above that says always. And then guess what? Even the configuration of the soft drink bottle is a trademark owned by Coca-Cola. There are also some very cool non-traditional trademarks that include sounds, colors, shapes, motion, and a hologram. And even, as we mentioned again, the configuration shape. Almost anything can be a trademark, as long as it indicates the source of the product or service. Some examples. For sound marks, you can think of a lion roaring at the beginning of a movie. The trademark, MGM. If you think of the color pink for home insulation that you put in your walls, you might think of the owner, Owens Corning. What about the scent of Play-Doh? Did you know that that was a trademark? That type of clay toy for kids, the scent is a trademark owned by Play-Doh. Holograms. If you think of the sticker that's on the American Express card or on trading cards like the Upper Deck, that hologram is a trademark. And what about the shape of a Weber grill? If you see a grill that's shaped in a certain way, it might be a Weber. If it's a Beetle car that's shaped like a Beetle car, it's owned by Volkswagen. So here's a pop quiz for you. First one, does a federally registered trademark mean that you own a word or phrase? The answer, no. It only means that you have the exclusive right to use that word or phrase to indicate the source of your goods and services. Here's another one. Do you have to use your business name as your trademark? This question comes up a lot. The answer, no. You can, but you don't have to. Instead, you could develop a very creative trademark to help your customers find you in the marketplace. So what are some of the advantages of obtaining a federal trademark registration? Well, traditional trademark rights in the United States are based on use. The first one to use a mark in commerce to identify a specific good or service has a trademark right, a common law right. This means that you don't ever have to register your trademark with us, but you would miss out on some significant benefits. Trademark rights are created in 2 ways: common law, like we just spoke about, or federal registration. Registration under common law, as I said a moment ago, is not required. It is your choice as a business owner. Common law trademark rights are created under state law and can be very powerful, but they're also limited. They are created as soon as you start using your mark in commerce. Common law rights are limited to the area where the mark is used. For example, if you're using your trademark in Minneapolis, your rights are limited to Minneapolis. But what if you want to grow your business? You might consider a federal registration. What kind of symbols can you use if you have common law rights and not a federal registration? Well, you can use the TM or the SM superscript. They're optional and not required. It puts folks on notice that you have ownership rights that you're claiming. One thing though, you can never use the R in the circle unless you're registered with us. That's a perk of having a federal registration. Federal registration rights are created when the trademark is registered with us, the United States Patent and Trademark Office. Now, when you own a federal registration on the principal register, there is a legal presumption of a few things. One, that you have a valid ownership of the mark. You have an exclusive right to use that mark nationwide in connection with your goods and services. But these presumptions may be rebutted in a court proceeding, but you start on the right track, having a legal presumption of some really important rights. There is no legal presumption related to the use or ownership in other countries, though, because remember, the United States Patent and Trademark Office provides nationwide United States protection only. The federal registration also provides notice. Notice is implied. It's called constructive notice, and it occurs when your trademark is published on an official gazette through our office. Anyone in the world can look at the official gazette and they can see what marks are registered or which marks have published who are on their way to registration. They have an opportunity to object at that point, and that is called notice. Also, your mark, when it's registered, and even when you submit your application, it is listed in our United States Patent and Trademark Office database, which again makes the public aware of your claim of ownership in the mark. As soon as you register your trademark with us, you receive some terrific benefits. Let me share those with you. Number one, you can bring an action in federal court, not just state court. Number two, you can record your federal registration with U.S. Customs and Border Protection. Now, this is a great way to stop the importation of counterfeit goods. What if you work in an industry that's plagued with a lot of counterfeit? Let's say you make electronics, sneakers, handbags, or pharmaceuticals. If your goods are constantly being knocked off, you can add your federal trademark to a list at the U.S. Customs, and they will be on the lookout to stop the importation of any counterfeit goods that might include your mark that may be entering into the United States, and they can seize them. This is a good thing. You can also use your federal trademark registration as a basis for filing in another country. How? Well, under the Madrid Protocol, which is an international agreement, you can use a U.S. trademark registration or application to support the filing of an extension of protection in another country. The filing is processed through the World Intellectual Property Office. And when you get your slides, you'll see a link that will take you right to a page to share more information about this. Once your mark registers, though, you get to use the coveted R in the circle. But remember, it's your choice. Now, why might you decide to register? Well, you might want to prevent competitors from using it. Maybe you spent a lot of time creating it, and so you want to protect it. Maybe you want to associate the mark with a large product launch, Or maybe you want to show your investors that you mean business and you take your intellectual property seriously. All of these are valid reasons to register your trademark with us. Another pop quiz. Do you have to register your trademark with us? What do you think? If you answered no, you're correct. Federal registration is a choice, and many trademark owners decide to apply mainly because they want nationwide rights that the registration provides. Let's see, does registering your trademark with the USPTO give you international protection? What do you think? No. Registering your trademark with the USPTO only provides rights in the United States and its territories. Let's jump into how do you select a trademark? In this section, we're going to explore how to select a strong trademark that can sail right through our review process. As we move through the next slides, there are a few things I want you to bear in mind. Our mission is to register marks. We would love to just register all the marks that are submitted, but we have to go through a series of steps to make sure that the marks are acceptable and registrable. Remember, you're not buying a trademark. You are applying to seek federal registration with no guarantee. Your goal is to select a mark that's both federally registrable and enforceable or legally protectable. You want to be able to register it with the USPTO and be able to enforce the registration against competitors. But guess what? Not every mark is registrable, and every mark is not enforceable. What do I mean by that? Think of this. Think of Levi's. What if Levi's relies on common law rights? They never register their mark with us. What if a competitor tries to register the wording Levi's for jeans? Can the competitor enforce her rights? No. Levi's has been using the mark longer, even though they don't have a federal registration. So Levi's would be able to cancel the competitor's mark. Remember, the earlier user of the mark will always have superior rights, even above registration rights. So you want to be sure to select a trademark that is federally registrable and legally protectable. Before we get to the likelihood of confusion analysis, let me just remind you that we cannot provide advice or answer questions about similarity in specific cases. But submit your questions and maybe we can see what we can help you with. But do not submit questions asking whether a particular marks are similar. That we cannot answer. We can discuss, we can only discuss registration issues. We cannot provide advice about enforceability. So let's talk about these two concepts. How do you select a strong registrable trademark? Well, first, you want to avoid some of the common refusals that the office looks for. Likelihood of confusion and descriptiveness. So let's talk about how to select a trademark and to avoid a likelihood of confusion refusal. One of the most common refusals is likelihood of confusion. The USPTO wants to make sure that consumers are not confused about where goods and services originate. So what's the test? You want to look at the marks and you want to analyze two marks side by side, your mark and maybe a competitor's mark, or two marks that you're trying to make a determination of whether there's a likelihood of confusion. You want to look at what they look like, the appearance, the sound, and the meaning. And then you want to say, do they create a similar commercial impression in the market? You also want to look at the goods and services offered under each mark. You want to analyze Are the goods and services related in some way? Will consumers mistakenly believe that the goods and services come from the same source? If the marks are similar and the goods and services are related, there is a likelihood that the registration will be refused because of likelihood of confusion. But remember, many times identical trademarks can coexist in the marketplace. Think about the word Dove. Dove is a trademark for chocolate. It's also a trademark for bath and body products, soaps, lotions. The marks are identical, yet they're both registered and coexist because the goods are unrelated. Chocolate and bath products are not really related. It's not really likely that they are offered by the same product, the same owner. Have you ever heard of a company that makes chocolate and soap? Not likely. That's why they can coexist. Another good example is Delta for faucets and Delta for air transportation services. Different streams of commerce, but identical marks. No likelihood of confusion. Here's an example. Well, really another pop quiz. Look at these two marks. Would you say that there is a likelihood of confusion between them? First, we're going to look at the mark, T. Markey. The other one, T. Markey. So the marks are identical. Let's look at the goods offered under each, shirts and pants. Are they related? Can you think of a company that sells shirts and pants? I can. That's why these two marks, if your mark was T. Markey for shirts and there was a registered mark for T. Markey for pants, it is likely that your mark will be refused because the marks look the same and they sound the same and the goods are related because consumers are used to seeing one company make pants and shirts. Let's do another example. T. Markey, T. Markey versus T. Markey. Do they look alike? Not really. Do they sound alike? Yes. Do they mean the same thing? Yeah. Look at the goods offered. Shirts and pants again. Are they related? Well, based on the example before, they are. And so what do you think? If your trademark was T. Markey for shirts and the registered mark was T. Markey for pants spelled differently, they would be refused. Your mark would be refused. These marks sound the same. The goods are related. There's a problem. There's a likelihood of confusion. Let's do another one. What if your mark was T. Markey for shirts and the registered mark was T. Markey for golf flags? Question is, would your mark be refused because of the registered mark? Let's do our analysis. T. Markey versus T. Markey looking the same, looking differently, sounding similar. So the marks are similar meaning. We'll look at the goods, shirts versus golf flags. I don't think I can think of a company that makes golf flags and shirts, but I'll have to do some research. If I can find like 10 companies that do that, maybe I can find a number of companies that do that, then I might say that they're related. But if I cannot find the evidence to support, then I would say that they're unrelated. Probably not refused in this case, but it would require some research to determine the real answer. That's why you do a clearance search before you file your application to see what the risk is for submitting it, the risk of whether you're going to get a likelihood of confusion refusal. So how do you determine which marks may be confusingly similar to your mark? Well, we suggest you do a clearance search. TES is the system that we use, and it provides a free search. It's available 24/7 unless maintenance is being performed. The USPTO database that you're searching, though, this is one thing you must remember. It consists only of information related to registrations and applications. It doesn't display any marks for which only common law rights exist. So that means if your competitor has never registered their trademark in our with us, and so it's not listed in our database, you will not find it when you do the search. And that is why it's so important to do an internet search. The internet is a place where you can find lots of owners using different marks. Some are registered, some are not. Remember, the earlier user will always have superior rights. While searching is complicated, you should always at least try to perform a search and test our system before considering hiring a private trademark attorney or a search firm. Now, why is that? Well, if you found one bad result from a search that you conducted with us, it might steer you to perhaps select a different mark. But you can always hire a search firm. Be aware, though, that the search firm will probably, likely, typically, generally, just gives you a big binder full of results, and they will not necessarily help you analyze them. But you can still consult a third party to help you in this regard. When you do a full clearance search, notice you're searching our database of registrations and applications, state trademark databases, business name registries, and even foreign trademark databases. You're searching also the internet. And that is why a full clearance search is recommended if you want to lower the risk of finding a mark that is confusingly similar to yours. If you want to lower the risk of actually getting a refusal from the PTO, you want to conduct a search. I hope that's clear. But in the question and answer period, you can ask me to maybe repeat that or to clarify. Here's another pop quiz. Two different marks, side by side. What do you think? We have your trademark, X-seed, for agricultural seeds. And then we have a registered trademark, X-seed, for live plants. Let's do the analysis. First, we're going to look at the marks themselves, X-seed and X-seed. Are they similar in sound? Yes. Appearance? No, slightly different. One has an X in it, one does not. One has a hyphen, one does not. Meaning? They mean about the same, maybe. Questionably, maybe X-seed might mean like cross out seeds. I don't know, but when you hear them though, they convey the same meaning. Your mark is used to register agricultural seeds. The registered mark is used to register live plants. Are these related? Can you think of a company that sells live plants and seeds? I can. Home Depot. But you also might think of a nursery. And so it's likely that this application or it's likely that your mark would be refused because of this registered mark. Similar marks, related goods. Okay, you guys are experts at this now, I hope. Let's talk a little bit about how do you select a strong trademark. So we've talked about likelihood of confusion. What about selecting a strong trademark? When you select a trademark, you don't want to use marks that are descriptive because those marks cannot identify the source of goods. Ask yourself, does this mark describe my goods or services? In other words, does your mark describe an ingredient of your goods, quality of your goods, characteristic, a function? Do they describe a feature of your services, the purpose of your services, or the use of your services? If so, there could be a problem. It might be considered that your mark might be considered to be descriptive. Here's a good example. What about apple pie for potpourri? Apple pie, does it describe a feature of potpourri? Well, it describes the smell, the scent, and so it would be considered descriptive. What about bed and breakfast registry for lodging reservation services? Would that be considered descriptive? Perhaps, because a bed and breakfast registry is an example of a lodging reservation service because they have that service. It's a feature. It's a purpose of the bed and breakfast. Is the purpose of it is to reserve lodging. So it's likely that that would be considered descriptive, and so it would not be considered a strong mark. If a mark is merely descriptive, it doesn't function as a trademark because folks see it and they don't immediately think of the owner or the origin. They just think that the word describes what's offered. This infographic ranks the types of marks based on strength. The strongest marks are fanciful and arbitrary. The weakest marks are generic. What are generic marks? Well, generic marks are not really marks at all. Generic terms are common, everyday names for the goods or services, and they're not registrable. One good example is milk. If you try to use milk to identify your dairy-based beverage, you're likely going to get a refusal because it's generic and milk cannot be used to identify a dairy-based beverage because milk is a generic term for dairy-based beverage. These marks are not really marks at all. What is a descriptive mark? Well, a descriptive mark describes a feature of the goods or services. Difficult to register, difficult to protect. They describe ingredients, quality, characteristics, function, features, purpose, or use. Unregistrable on the principal register. Unless you can establish that your mark has over time acquired distinctiveness. For example, if you own a mark and it is considered descriptive, you may be able to show after 10 years of use, perhaps, that your customers no longer view your mark as descriptive, but in fact, they now consider it to be a trademark, but you'd have to provide some evidence to support that, maybe some surveys or some other information that could show how you were able to arrive at this conclusion that your mark was no longer descriptive, but in fact functioned as a trademark. Let me give you a good example of a descriptive trademark. Creamy whip. Creamy whip for whip topping. Descriptive? Well, you could say that most whip topping is creamy and it's surely whipped. So you would say that off the top it's descriptive because creamy and whip describe features of the goods. But in this example, this mark was able to be registered based on a Section 2F acquired distinctiveness claim and the fact that whip, which is the generic portion, was disclaimed. So it is possible. It takes a little bit more work, a little bit more maneuvering, but you can sometimes register a descriptive mark if you take these additional steps. Okay. What about a suggestive mark? Remember, we're still going through our infographic from marks that are the weakest to the strongest. Okay, so now we have gone through generic, we went through descriptive, and here we are at suggestive. A suggestive trademark is a mark that requires a consumer to use their imagination to determine the nature of the goods and services. In other words, suggestive marks suggest the nature of the goods. Okay, they are registrable. And one of my favorite examples is copper tone. If you use copper tone, you hope to get a golden bronze skin color based on your time in the sun. You don't necessarily get the color of copper, but it suggests that you're going to have a beautiful bronze complexion. Copper tone is used for suntan lotion, and so it's considered suggestive and it is registrable. There's a couple of steps you have to take to get to the actual good. Copper tone, bronze, color, suntan lotion. Okay, not completely descriptive, using your imagination. I love suggestive marks. They're fun. What about a fanciful mark? This is another mark, even stronger than a suggestive mark. Fanciful marks are marks that are invented. They're coined, made up words with no meaning at all in any language. Fanciful marks are registrable. Think about Xerox for photocopiers. Xerox is a completely made up word, and so it makes a terrific example of a fanciful mark. Another one would be Kodak, Kleenex, Pepsi. Made up words that make terrific, fanciful trademarks. What about arbitrary? Arbitrary marks are real words that have no association with the goods and services identified. Arbitrary marks are registrable. Good example would be Apple. Apple, used to identify computer goods, not fruit, is a great example of an arbitrary mark. What about the Gap, used to identify clothing, or BlackBerry, used to identify a mobile device? Knowledge check. We got another pop quiz for you. Look at these two marks. Are they registrable? Now remember the two refusals that we've discussed today: likelihood of confusion and descriptiveness. What do you think? If you did analysis for likelihood of confusion, you might say that the marks appear the same, they sound the same, they mean the same. So the marks are similar. If you look at the goods, bicycles versus playing cards, are they related? You might say no, because maybe you can't think of a company that makes both. But are you out of the woods yet? No. Now you have to do another type of analysis, a descriptiveness analysis. Is your mark descriptive? Is there another reason why this mark might be rejected? Well, if you are a company that sells bicycles and you want to name it bicycle, well, you're going to have a problem because bicycle is generic for bicycles. That's going to be a no-go right there. What about bicycle for playing cards? Well, you might say that is arbitrary, and it was registered. Registration number 0048891. What is the process for filing and obtaining a registration with us? Well, there are 4 steps in the trademark registration process. Broad strokes that every application goes through. The 4 steps are application, examination. So first you submit your application through our online portal. It arrives in our database. Your examining attorney will do a random pool of cases, and then it arrives on their desk for an examination. The attorney is reviewing your application and looking for any type of procedural issues or possible refusals. If your mark is approved, it's published in the official Gazette. And if no one objects, it moves to registration. Remember, not every trademark registers, and it's very important that you understand the process and the specifics of the application before you file. The application looks deceptively easy, but there are a lot of hidden issues in those questions. So be sure to pay attention to some of the nuances, and you can find all that information on our website. Electronic filing is mandatory, except in very rare situations. There used to be a time when we would accept mailed in applications. When I was working in the office back in 2000, We used to get hard paper files, and folks could mail in things, and they would even mail in samples of things to show what their mark on actual goods in the marketplace. And kind of fun because I was in the office for cosmetics and like fashion goods. So I loved it because I would always get a bunch of wonderful samples. But these days, everything is electronic. And so you can file your electronic application using our online TEAS filing system. A TEAS Plus application is cheaper. It's $250 per class. It's more upfront. The filing requirements are very clearly laid out, and that's why you get a lower filing fee. It's actually easier for an examining attorney to review a TEAS Plus application, and so that's why those tend to get reviewed the fastest. There's also a TEAS Standard application. This one has less upfront filing requirements, but it has a higher filing fee, $350 per class. Now you could use your ID manual to determine to determine where your goods and services fall to help you figure out how many classes are intended. And you can use the ID manual, which is a database, and it will help you to identify whether your description of your goods is acceptable. Okay. The total fee for how much your application costs is determined by the number of classes that you select. So let me give you an example. What if you're a fashion company and the name of your brand is Fabulous? Under this brand, you want to offer a number of different goods. So let's think about it. Think about your favorite fashion company, perhaps Gucci, okay? Gucci sells a lot of different things. Let's see what type of classes Gucci might have to pay for. If they want cosmetics, cosmetics are in class 3. Sunglasses, they are classified in class 9. Jewelry, classified in class 14. What if they want to sell mugs and under the Gucci brand? They're in class 21. What about apparel, t-shirts, pants, jackets, coats, class 25? What about shoes, class 25? And what about retail store services featuring clothing, a retail store, or online services, class 35? 6 classes in all at $250 is $1,500. 6 classes at $350 is $2,100. So that's how you classify, or that's how you determine how much money your application is going to cost, is based on the number of classes. And if we have some time, I'd love to take you to the ID manual itself so that you can see how easy it is to just drop your wording into our search engine and then see all the results that come out of the different options of the types of ways you can describe your goods and services and what class it's going to be classified in. Application requirements. There's certain requirements for all applications. You must have a clear drawing of the trademark. Now, don't let the word drawing confuse you. We use the term drawing to mean the iteration of your mark. So if you want your mark in all capital letters in black, if you put your mark in all capital letters in black text, you would have really strong protection. We would call that mark in all capital letters the drawing of your mark. And it means that you can use your mark in any color and in any font. What if you submitted a black and white drawing, like the black and white half-eaten apple that's used by Apple Incorporated? Well, that mark in a JPEG formation that's in a black and white means that you could use that mark in any color in that same design, but we're calling that a drawing. Another thing that you'll have in your application is a listing of goods and services that are used with your trademark. Remember, I mentioned the ID manual. If you put ID manual USPTO in your search engine, it'll pop up and it'll be a way for you to select specific goods and services, but you must have goods and services listed in your application in order to have a valid application. Because remember, all trademarks are tied to specific goods and services that are listed in your application. You need a basis, a filing basis. Every application has a filing basis for each good and service. This is the legal reason why you're allowed to register your mark with the USPTO. You either are intending to use your mark in commerce or you're actually using your mark in commerce and has some dates to support that. You also have to provide some contact information for your trademark owner, a filing fee for your T's filing option. Remember that $250 or $350 per class amount. So thus far, we have discussed two common reasons why your trademark application may be refused. But you know, there are more than just likelihood of confusion and merely descriptive refusals. There are geographically descriptive refusal. For example, if you wanted to use Virginia in the name of in your mark, it's going to be a problem. You may get a geographically descriptive refusal. Or what if your specimen that you provide doesn't support your use? For example, what if you're making cosmetics and you have your mark fabulous on the cosmetics, but you submit a sample that doesn't show the mark fabulous on cosmetics? Your specimen will be rejected, and that will be a refusal. Or ornamental usage. What if your mark is used in an ornamental way? If it's used in an ornamental way, think about this. This is a common ornamental refusal. Let's say that your mark is fabulous and you're using it on t-shirts, and you submit as your specimen a t-shirt with the mark fabulous in the middle center in giant letters. If you do that, it's likely you will get an ornamental refusal. And let me explain why. When a mark is large and prominently placed on the middle of a t-shirt, if a consumer encounters that, it is unlikely that they will believe that that wording on the front indicates where the mark or where the shirt came from. If they want to know who made the shirt, where do they generally look? They generally look at the hang tag or the label in the back. And so if you provide a specimen that has it on the front like that, it's likely it'll be rejected. You want to make sure that your mark is not used in an ornamental way, and so that your specimen does not show that. There are other reasons to reject a trademark application, to refuse it. What if your mark is a last name? My last name is Terrell. If I had Terrell as the name of my brand, that's primarily merely a surname, it's likely I'm going to get a rejection. What if it's a character name? Mickey Mouse, okay? If it's a character name, it's unlikely you're going to get a registration. It's likely it'll get rejected. What if you make music or you write books? The title of a single creative work is not sufficient to establish trademark rights. And so you need to show a series. That would be more than one, okay? So those are some other refusals, and you can learn more about those on our website. And also if you sign up for our Trademark Basics Bootcamp, which I'll talk about in a minute. Once you obtain, we're back. Once you obtain a registration, you still have work to do. You have additional responsibilities in order to keep your registration alive. You must enforce your own trademark rights, okay? So that means that if a registrant, you, becomes aware of any infringement, it's your obligation, your duty to take action to try to stop it. You may use your registration certificate to support a cease and desist letter, or you may use your registration to sue an infringing user. Another point is a trademark can last forever if you file the required post-registration documents with the USPTO. And these documents have to be filed between the 5th and 6th year after your mark registered. So if you're mark registered, you want to count 5 years from that registration date. And between that 5th year and the 6th year, you want to file registration documents. You want to do it again between the 9th and the 10th year. And then every 10 years after that, as long as you do that, your trademark can last perpetually. How exciting is that? But it's government. So for every renewal, you have to pay additional fees per class, and you must show evidence of continued use. So that again means that you have to submit specimens again, samples, or evidence of how you're using your mark in commerce. Knowledge check, another pop quiz. Are you guaranteed registration of your trademark? What do you think? If you answered no, you're right. Every application must be examined before it can be registered. Your application may be refused because of procedural issues or substantive issues like likelihood of confusion or descriptiveness. But you have an opportunity to overcome this and argue against the refusal, but registration is not guaranteed just because you submit your application with us. And I'm sorry to say, your filing fees are not refundable. Another knowledge check. If your trademark registers, do you have to do anything to keep your registration alive? Answer, yes. You must continue to use your mark in interstate commerce and continue to file the required post-registration documents. We did a lot today, but I want to keep pushing on because I want you to figure out and to know more about where you can go for help. Please beware of scams. Unfortunately, the trademark industry, like all industries these days, has to contend with scammers and fraudsters. Scammers are third-party businesses that contact trademark applications and registrants, contact trademark applicants and registrants, trying to get them to pay for fees and services that are not required. Please be aware of these companies. This first website here will give you 10 things you can do to protect yourself. Please also know that there are filing firms that will try to draw you in by advertising low cost to file your trademark application with us, and who will say that they can guarantee registration. This isn't true. As we've discussed, the fees are clear. They're $250 per class if you do our T's Plus, $350 per class if you file with our T's Standard, and no one can guarantee registrations. Beware of solicitations, misleading notices. Everything you file with us becomes public. That means that if you include your phone number, it becomes public. If you include your mailing address and don't use our special way to shield your mailing address in our system, it becomes public. And so third parties who are looking to find different contact information for folks in the trademark space will scrape this information and use it to send you solicitations. Now, some of these are legitimate, but many are scams trying to convince you that you need to pay like 4,000 euros or something for what the services we offer. Remember, $250, $350 per class, that's it. Those are our filing fees. USPTO resources. What type of learner are you? We have resources to fit any type of learner. We have a website that provides narrative and some images, that has videos. We have trademark videos that can be found at this link right here, Basic Facts About Trademarks, this Trademark Information Network, which is a really great series that features my supervisor, Jason Lott, talking about trademarks and what the things that you need to do, and also the T's, nuts, and bolts. We finally have a toolkit that has flowcharts infographics, and narrative text. If you're interested in learning more about the registration process, I invite you to attend a free series of comprehensive webinars. The series happens quarterly. It features 8 different webinars. The next round starts on April 4th. There's one happening today at 2 o'clock. It's from 2 to 3 and then 3 to 3:30, question and answers. There's a link right here on these slides. It's where you can go on our website and see. Plus, you can sign up to receive alerts of when the next series is going to launch. We have an IP identifier that will help answer simple questions. What if you're trying to determine exactly what type of intellectual property you have? Is it a patent? Is it a copyright? Is it a trademark? You can go to this link here. You can find free services that include patent information and trademark information and programs. We even have a virtual assistant now, which is in beta only, but it covers about 25 of the most common asked trademark questions. Or you can even put your application number there. And if you put your application into the chat or for the assistant, it'll actually show you the status of where you can go to find the status of your application or registration. Really simple tool. What if you want to talk to a live person? Wouldn't that be great? Well, from Monday to Friday, from 8:30 a.m. to 8 p.m., you can call this number, 1-800-786-9199, and speak to a real person who can help walk you through the trademark application process. The calls are answered quickly, but email responses can take a day or so, okay? It's time for questions and answers. I can't wait to hear from you. Just a few reminders, we can't comment on the registrability of any marks, including the validity of registrations. We can address IDs contained in live applications because those are still in examination, but we can talk about so much more. Thank you for joining us today, and I hope this was helpful.
Thank you, Marisa. That was very informative. We do have a few questions. So let me pull those up. Okay, so this one's a little bit long. How does company name and logo trademarking work? Logos keep changing over time. How can a company secure its logo as well as its company name? And then in parentheses, a good friend of mine had to rebrand because her company name was similar to someone else in a different state, but had a trademark on the name.
Right. So you can file as many trademark applications you want with us to protect as many trademarks that you'd like. And your trademark can be a company name if that's what you decide, as long as it's being used in the marketplace to identify goods and services. It could also be a logo or a design. It's your choice. But you're right, the benefit of the trademark registration, of applying with us and obtaining a registration, is that it does provide stronger protection than common law rights, and it gives you nationwide protection. I hope that's helped to answer your question.
What is the process for reviving a dead trademark that I registered years ago?
Unfortunately, when your mark is abandoned, you only have a very short window. I think it's 2 months to revive it. If you don't get your revival application in, your petition to revive, unfortunately, you're going to have to reapply, starting from scratch. And I encourage you to do that, because typically when folks see that a mark is dead on our register, they think, oh my goodness, I can get in here and get ahead of this person. But the good news is that if you have continued to use your mark since your mark died, quote unquote, you do have protection under common law rights. And if someone tries to scoot ahead of you by filing an application with us during the time when maybe your application has died, you still have prior rights because you have been using before, if you can establish that. So I wish you luck with that.
Why does the process take so long? I sent mine in months ago and it still hasn't been assigned. I did it through Trademark Engine.
I'm not familiar with Trademark Engine, but if you look up your application in our system, you can see whether your application has been assigned to a lawyer yet. Unfortunately, you're right. We have a backlog. I'm going to tell you, I just transitioned from being an examining attorney about 2 years ago. No, October. I just transitioned to this new position. And I want to say, we had so many new applications during the pandemic because everybody was thinking, aha, I'm going to create a new business, that we got so far behind. The pendency, I think, is 5 to 6 months before an examining attorney will get your application, but you might be further along than you think. Check in with our TSDR. So remember, go to uspto.gov and you can go into TSDR to track your application and see where it is. And you might be surprised, maybe it's been assigned. And if it's been assigned, if it's on someone's desk, they have a requirement to get it off their desk in a certain amount of time. And so you'll be sure to know that it's going to be moving quickly after that.
All right, I'm going to follow up. This attendee that just asked that question, she's saying it is still in the system and not assigned.
Unfortunately, I think you're part of that long list of folks that have not been assigned. But the good news is, once you file, you get a filing date. And so no one who has filed later can trump your rights, can jump ahead of you. So you are in the queue. And so you know that you're going to have when they do a search, they will only be searching for marks that were filed before you. So that you don't have to worry about losing ground during this period.
How do you find the state and foreign trademark databases? Do you have to look at each individual state and country government's info, or is there a clearinghouse of some kind? What is a business name registry and how do you find those? So there's a couple questions if you need me to go back.
Right. Unfortunately, we don't recommend specific ones, but if you do it just a general search, there are lots of third-party companies that do it. But I would suggest you hire a lawyer to be the one to help you navigate that, because there's so many fraudsters and scams out here that you would think that you are contacting a company that's going to conduct the search for you and do it in a good faith way, an honest way. But unfortunately, many folks are simply just throwing your mark in Google and sending you back those results. That's not what you want. You want a lawyer who's going to connect with a reputable search company, who is going to get a binder of search results, that literally 2 binders. I remember when I used to work for in corporate America, you would get 2 binders of like 400 pages, and we would be tasked with going through these binders to find if there was anything confusingly similar. But you did ask about the records. Yes, you can go to state records and do a search. I know in DC, if you're in Virginia, if you go to DC, there's the business, the consumer, what do you call it? They've renamed our consumer office. But where you go to register your business name, you can go do a search of anyone's business name and see if they have a name similar to yours. You can do that for each state. But wow, it does take some time to do.
Okay, this one is a follow-up because you did sort of cover how do you see if someone else has your trademark. That was their original question, or if it, if it's available. They're wanting to know if it's possible to do a search live as an example.
Okay, let's try. So let's see now. I don't, why is this, I've got, trying to take this off of full screen, but I'm not able to do that. Let me just pull up a new window. Okay, let's do that real fast. Okay. Here I'm going to go to Tess. If I can spell today. Let's go to Tess. And let's do a search. So you see these options here. I am in, so what I did is, I'm going to go back. So if you're on Google, and I want to go to my Tess search engine. Okay. Search trademark database USPTO. Okay. Pulling that up. search, this is our website. So you're going to search our trademark database. I've got 3 different options. The basic word, the simplest option is the first one. And let's say your mark is fabulous. Fabulous. I want to make sure that I select the right index. I want to look for the mark, the word mark. I am not looking for the serial number or the owner's name. I want to just look at the mark, and then I want to hit submit. Look how many I got. 1,800 marks, right? It'll let you look at them in sets of 50, and you would just keep scrolling through the next list, next list. What if you wanted to narrow? What if you only wanted to look at fabulous for cosmetics? Well, I could do cosmetics, and I could do for goods and services. You see how I put that GS in the bracket? And now it's going to show me only cosmetics. I want to take you back so you can see all the different search options you have. If you look at this third option, you see down at the bottom, these are all the different search indexes. So if you want to look at your mark, you're using the basic index, BI, or if you do the simple, it'll just put up this combo. And then if I want to do and cosmetics, I want to limit it by just goods and services. Notice, let's see, GS, goods and services. Or what if I wanted to limit it by class? I could say 003 because I already know that cosmetics are in class 3. And now I'm only looking at the word fabulous with the marks that are classified in 3, which includes cosmetics, lotions, oils, you know, all that kind of stuff. I'll do my query. I only got 211 records, and I can look through each one. And let's say, look at this. Let's see, Tom Ford. We won't look at that because that's got us. Oh, look, Tom Ford, fabulous, okay. Abandoned, but look at all the information I get. Here's the mark. Here are the goods and services for non-medicate skincare. Here's the owner, Thomas Ford, and I can see it's dead. And guess what? If I wanted to even see more, remember how I said that everything that you file and submit is in the public domain? If I wanted to see everything in his file, I can see it, his application right here. So if you need some help, you're trying to figure out what to do, maybe you find another similar mark to see how if it registered now. You want to make sure you look at the ones that are live and that have registered, give you some help on what to do next, okay? I hope that was helpful. We went really fast through it. I encourage you to join us for the Trademark Bootcamp, where there's a whole hour on searching.
And someone did ask the question, can you drop in the chat the link to that?
Sure, let's see.
Because this email will go out after the fact, and if there's one this afternoon, I don't know if it's too late to sign up for that one.
Okay. Oh, for the basic bootcamp?
Yes.
Oh, sure. Okay.
Thanks.
All right. What can I? I had all these open, but for some reason I cannot get this into. Okay, that's all right. I will find it for you.
Okay.
Let's see if I can do it this way. There we go. Came right up. How amazing is that? Never happens. Okay, I'm going to copy this and let me see if I can find the chat in here. Ribbit. Where's the chat? Oh, there it is. Okay. All right, here you go. There's the boot camp. We've got one going on. It starts at 2. This one today is just a general question and answer period with different experts. It's the last one of the series, but we start again on April 4th.
Okay, great. Okay, we have a bunch of questions, so we'll kind of pony through these.
Okay.
What would taglines count for trademarks, or should they be registered a different way?
Taglines are slogans and they are trademarks. So remember, when we looked at that Coca-Cola slide, there was the real thing, you know, that's a slogan. And so they have to be protected in the same manner you would do a design or a word. So same application process, nothing different. It's just a longer search because you might have 4 words. And so you're looking for, if the mark was it's the real thing, you want the word it's plus real plus thing to see what you can find. And then you would probably do some patterns of it's and real, it's and thing, real and thing to do your complete search.
Can you review again the difference between using the TM versus the R symbol?
Yes. You use the R symbol only when you have obtained federal trademark protection and registration through us. So unless you have filed an application through us, it's been reviewed, and then you finally got a certificate in, via email, you cannot use the R in the circle. So that is like a perk only for if you have a federal registration with us. Otherwise, you use the TM and the SM superscript. That's just indicating that, hey, you came up with a wonderful brand name, a design, a logo. You have using it in association with specific goods and services in the marketplace, in commerce. Now you're using, you're relying on common law rights, and you can use SM and TM. Optional, but it's a good idea to use.
Great. When you submit a drawing on the application, can this be a logo?
Absolutely. And the logo would be submitted as a JPEG. You would upload it through our electronic system. It gives you like a wizard. It says, hey, you want to, do you have, there's a blank. It'll say, is it a standard character mark? That would be a mark only in words, capital letters, or design, and then you would upload your JPEG there. If you did it in black and white, you would be allowed to use your mark in commerce in any color. If you do it in a color, then you will be restricted to using it only in that color.
Are the fees paid per application or per approved trademark?
They are paid per class. So remember that we talked a moment ago about, let me put, let's look at the ID manual. ID manual in your Google and maybe USPTO, okay? And I'll give you the link in just a minute. Trademark ID manual pops up first, but it might be because I use it so much. I'm going to copy this and put this in the chat right now in case you want to walk with me through this. Okay, there's our ID manual. Your fee depends on how many classes you have. Now, remember my example of Fabulous, who is a fashion company. If that fashion company was offering cosmetics, you would put a search in and you see that cosmetics is in class 3, right? That's $250. What else? What if they're doing sunglasses? Class 9, $250. What if they're doing pants? Class 25, okay? Every good and every service in the world has been classified by our wonderful eager beaver government officials into classifications, numerical classifications. And depending on the number of classes, that's how you calculate your fee. Number of classes, not number of goods, number of classes those goods fall in. So if you're offering clothing, pants, shoes, hats, socks, 4 different items, all in class 25, one fee for $250 or $350, depending on which application you choose.
All right. What if you originated your business name and others are using it? Do you have any rights prior to TM?
If you have a business name that you're using as a trademark and you're using it in commerce, meaning you have associated with a good or service and you're offering it for sale in the marketplace across state lines in commerce, okay? Then you have common law protection. And so you can attempt to enforce your rights against someone else who might have started using their mark later. You don't have federal protection, you have common law protection.
I created my trademark, which includes the name of my company, but I had it digitally designed by a graphic designer on Fiverr. Do I own my logo?
It depends on what the Fiverr licensing agreement says. For every different company that you go to, this is not legal advice, this is general information, okay? Every place you go to has a license. We typically click through those and just hit agree, agree, agree. Can I just get on with it? You got to read that agreement that Fiverr says, and there will be a clause in there that will tell you whether you have the right to use that image.
Just to clarify that until we can complete a USPTO registration application, we can use the TM mark without having to apply for common law. And is it feasible to do the registration application without a lawyer?
Okay, your common law protections attach immediately without you doing anything, provided that you have a mark that's associated with specific goods and services offered in commerce in the marketplace across state lines. Okay, if you can establish that, and you know the first date that you started doing that, if you can prove it, then that is when your common law rights attach. You don't have to do anything. You have to file anywhere. Okay, rights attached. I think sometimes you can file it through your state. Sometimes there are some ways that you can file, I think, through your state, but typically you don't have to do anything. Okay, if you want federal registration protection, then you must complete the application process with us. And if it's approved, meaning there's no reason why it's getting rejected for likelihood of confusion or descriptiveness or surname or any of these other obstacles, and it gets all the way to registration, now you can use the R in the circle and you have a stronger nationwide rights. Because remember, common law rights are based on jurisdiction. If you're using your mark in Virginia, you have protection in Virginia. You don't have protection in Delaware unless you have nationwide rights, or maybe you're selling on the internet and you have someone in Delaware that you sold to, then maybe you could establish some rights. But absent that, you're limited to Virginia.
Let's see. Okay, why is it necessary to register more than one time to protect trademark if the trademark was once cleared?
Well, if your trademark has not changed since it registered, you do not have to reapply, but you do have to renew it. And so this is the office's way of making sure that you're not just snatching words out of the English language and associating us with specific goods and services, and you're no longer doing it in the marketplace. Because remember, trademarks are supposed to help consumers understand where goods and services come from. If you are no longer selling, then you no longer have a trademark. And so periodically, the office is going to ask you, hey, 5 years after you registered, are you still doing this? Is this mark still in commerce? Show us some proof. Then it'll ask you again, 10 years after it registered. Is this still going on? I mean, businesses come, businesses go. We want to know because we're trying to clear out our database. And they'll ask you every 10 years from that point.
There's the boot camp today at 2. Are there other workshops? Would they just go to that link you provided to find those?
There are a ton of other places. Let me show you some more resources.
And actually you're looking for ones that you would be hosting. So you give really good information. So yeah.
Okay, let me see if I can pull this up. This is our toolkit. If you go to this page, okay, now see, how amazing that it actually came to the right page and then I lost the page. Okay, here. So here, the question was, where do you get other webinars and stuff? We have, let's see, is it on here?
So you went to the toolkit for that, which will be in the follow-up email.
It is, and I'm going to give you that link in just a moment. Actually, should I give it to you now? Maybe. If I can, let's see, can I do more than one thing at a time?
It's okay. It will be in the follow-up email because I think it was in the slides. So I think.
Yep. I'm trying to see if
we're looking at future ones.
Why does it keep doing that?
And we're down to about 10 minutes. So.
Okay, good. All right, so let's see. ID manual. I don't think this is it, but let me see if this is it. We have this thing called, okay, let me look at my own little cheats because I can't remember where all this stuff is, but I have it written down. Okay. Let me look at my links. Hold on, right? I'm almost there. I'm glad we have oh, here it is, highlighted in yellow. Okay. Let's see if it'll pop up. All right, here's our trademark webinar series. And here's some really interesting one. This is one I did most recently talking about NFTs and how if you're offering goods and services authenticated by NFTs, this is a great webinar for you to listen to watch. But there's lots of other ones here on, just lots of. We have like a video library here that has a ton of videos on just any and everything in the trademark space. And they're short, so that you can watch them as many times as you want, and they are free. So I am going to put this one in the chat as well.
Okay. And then we probably should move on.
Okay, let's move on. Yes, let's do that. Okay.
Okay, so what happens if the trademark does not exactly match the name of the patent filed name of the product? Is this a big problem?
No, it's not necessarily tied to patents. I mean, there's sometimes when things overlap where we actually look at patents specifically for marks that are considered functional in some kind of way. We might want to look at the patent for evidence, but typically owners, in my experience, might come up with a very complicated name for an invention or a process or a method. But when they hit the marketplace, they don't want to use like this big word. They want to come up with something that they have worked with a marketer to create, something jazzy. And so that will become their trademark. They will seek protection through the trademark process for the name that a consumer would encounter. And you can think of the pharmaceutical industry in that way. These long medical terms, they condense down to something that will be easily remembered, and that will become their trademark.
Okay. What if you have goods and services? Do you need to file two separate applications if the services you are providing also provide goods for that service? So
yes.
For example, travel, and then you have e-commerce t-shirts regarding the travel.
Right. So you want to be careful because when it comes to trademarks, we protect goods and services in trade. And what that means is that if you're off, it is what your main thing is. Your main thing is travel. It's likely that your services would be travel, and you would just simply put into the ID manual travel services. Look at all these different ones you can have. Travel information services, travel consultancy services, travel agency, namely issuing travel checks, traveler's checks, all of these different things. If you want apparel, you're going to have to specify exactly what type of apparel, but let's say you just want t-shirts, class 25, and so you can list in your application travel agency services in class 39 and t-shirts in class 25, two classes, $250 times 2 or $350 times 2.
Okay. To confirm, submitting a proposed trademark drawing for registration, doing so in black and white, all caps, provides the greatest level of protection / enforcement. That's
true. If you submit like the word fabulous, I can't get off of it today, capital letters, okay, black, and that means you just typed it in capital letters. There's no specific font. Then that means you're getting a standard character mark, which means any color, any font, any size. That's the type of protection you have. You don't have a design though. There's no design with it. It's just the wording.
This person's just confirming that the application is non-refundable if denied trademark approval.
That is correct. Anytime you apply, and let's say, even if you don't get to, let's say you abandon it before it even gets reviewed, maybe you just said, you know what, I'm just going to do an express abandonment. I don't even want to wait. No refund.
Okay. I have been working with an attorney and my TM is filed, but can I still call the USPTO office myself and get information that I need?
Unfortunately, once you hire a lawyer, your lawyer is the one that is in contact with the office, but you can simply tell your lawyer, I want to be part of these calls. Okay. Tell them you want to be on the call, and then let's see what they say.
And a follow-up to that, they wanted to TM the name and TM a logo, but the attorney said they need to be filed separately. Is this true, and about how much should this cost?
If you plan to use wording separate from a logo, you're right, that's two different applications. But many times owners will create a composite mark because they're using their mark. Their logo is actually a design element and wording all together. Remember, like that Coca-Cola image where it had the circle with the bottle in the middle and it had always at the top? That's a composite mark. But remember, your evidence would have to show whatever way you're using it in the marketplace. So if you're using them separate, meaning they don't intersect at all, they don't touch, then that's two different applications.
So is the fee for each class owed if your application is rejected?
Yes, those are the filing fees. And you have to prepay them. When you submit your application, you have to pay at that point.
Do you have to use the TM on your goods services in order to claim the common law protection?
You do not. It is optional. But it's a good idea because it helps establish to the public that this is a trademark. This is not just, I'm just not just using this mark to identify goods and services. I'm actually intending this to be a trademark. It's putting people on notice. And if someone comes later and challenges you, you can at least show, I've been doing this for 20 years. Do you see this TM? It's been up here for 20 years.
And is your contact info, was that in the slides? If not, can you drop it in the chat? That would be helpful.
Sure.
Thanks.
Let's see. Chat. But remember, one of the easiest ways, because I'm sometimes not available on the road, traveling, doing trainings, easiest way is to contact our TAC office, which is our, see if I can put that in here, our Trademark Assistance Center. Now you see that didn't come up at all. Nope. Oh, there it is. How wonderful. Okay. This right here, 1-800-24/7. Okay. You can call these folks and they will be happy to help you.
Great. I'll drop that in a moment. Okay. And this person, you, I think, went over this, but they're asking if you could just reiterate it. Is it feasible to apply for the registration without hiring a lawyer?
Absolutely. And in fact, we have what is called these clinics. Okay. I remember I used to manage a clinic at Howard Law School, law schools all over the country. These clinics right here, I don't know if you can see it because I got this chat open. All of these different clinics, and you guys are in Virginia, so many schools in DC, like American University has one, Howard University School of Law has one. You can go to these clinics. These student attorneys, with the help of their professor, will file the application for you, will walk you through the whole process. They'll do the search and everything. The only fees you pay are the filing fees. I encourage folks to have somebody help if you're not familiar with the process. But you can absolutely do it yourself if you take the time to review. There's also what's called a PTRC. These are libraries all over the United States that have been trained on how to conduct trademark searches, and they can also help. Not lawyers, but if you just want someone to talk to, they can also help. Let's see, do I have a PTRC? I do. I am shocked that well, I spoke too soon. Oh no, here we go. PTRCs are here all over the place. They can also help you. These resources, I'll just put them in the chat, but these are places where you can go to get some assistance at no cost. Okay. Put the clinic in.
Great. Okay. I think we're down to 2 questions. If your logo includes your slogan, do you file one application or multiple for each item?
If it's a composite mark, meaning it's a design and a logo together, remember back at like when we were talking about with the Coca-Cola one, I don't have it. How do I don't even know how to get out of that. But if you, oh, here we go. Let me see if I can go back and show you. It's way at the beginning. Wow, we did a lot. Let me see if I could do this a better job of this. Let me see. Oh, okay, not that one. It's another one. Oh, here. Okay, you see this mark right here at the bottom? this is a composite mark where there's a design element and wording. So this is one, good gracious, this would be one application. But if you separate them, like if you're doing it's the real thing, that's a slogan, and you want to do this design, those are two separate marks, two different applications. Did I answer that question? I think I kind of forgot the question, Sheila. Did I?
So it was, if your logo includes your slogan, do you file one application or multiple applications, one for each?
Okay, so this logo kind of includes a slogan. The slogan would be always Coca-Cola. So this example right here is a logo with a slogan embedded as a composite mark. This is one application. But if you wanted to do something like it's the real thing, and then you had like an image of a bottle, like, you know, that you use separately, two different applications. Does that make sense? I hope so.
So,
Okay.
okay, and then one last one. I'm not quite sure the question here, but my TM covers my children's books, but does not include products. And they're saying that they saw a product online that was using my name for a crochet product. My class only covers children's books.
Okay, so this is back to our analysis of likelihood of confusion. Remember, looking at the marks, are they similar? Are the goods and services related? The question you have to answer is, are crochet items related to children's books? I cannot think of anybody who sells crochet items and books, but maybe you can. And so if you can, and you can make an argument that they're related, then then maybe there's a problem there. But remember, there are lots of marks that are identical that exist in the marketplace. Remember the example I gave about Dove chocolate versus Dove soap? Same marks, they're identical. They identify different goods that are not related, and so they both coexist as two registered marks on our register. Because the argument that a consumer will be confused about who makes what, most people understand that Dove chocolate bar owners don't make soap, and so there's no confusion there. Okay.
Okay, I think we need to close out here. This was wonderful. And we've dropped your information, and I know there's lots of ways we're going to be giving people in the email, plus in the chat, to get a hold of the USPTO. So hopefully we can, if there's any other questions that arise, that can be handled. And I'm going to get us closed out here. I want to thank everyone for being here today. And so again, thank you for attending. You will receive an email that we've talked about with a link to the recording, an evaluation, and to the slides. And actually, I'm sorry, the evaluation I already posted. If you'd like to sign up for upcoming webinars or access recorded webinars, please visit virginiasbdc.org/training. These resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiasbdc.org or via our website. We hope to see you at our next session. Marisa, I want to thank you so much. This has been very informative and a wonderful presentation.
Thank you. It's been my pleasure. Everyone have a wonderful day.
Take care.
Bye-bye.